Are you driving or
Yeah, I did.
All right, we'll get started.
I mean, you should do it.
For those on video, welcome to Case Western Reserve University School of Law. If I don't know you, my name is Ned Searby. I'm an adjunct professor here in teaching criminal procedure 2. Today's program began as a guest appearance in the criminal procedure 2 class, and then we thought it might have value to others, so it was opened up. Thank you and welcome to all of you who are here. It's my pleasure to introduce Thaddeus Baraday and welcome him back to the law school from which he graduated and back to Cleveland where he worked. When I first met Thad, he was working for a large, distinguished law firm in Cleveland, Ohio, where he demonstrated his remarkable ability to work unimaginable hours as a M&A associate. From there, we lost touch, but there were brief anecdotes about Thad's life, including when WellCare went public on the New York Stock Exchange, and various friends that we have in common were trying to calculate Thad's net worth. But from there, the next anecdote was a troubling one. Was the day in October of 2007 when 200 federal agents hit the headquarters of WellCare in Tampa, Florida, and there my life and Thad's intersected to a degree. For me, it was like a time machine going back to my old life, because the office that was running one of the largest healthcare fraud cases in U.S. history was the office in which I worked. I was hired into the case to represent one of the executives by colleagues of mine from the U.S. Attorney's Office for the Middle District of Florida, who are now all on the defense side against our former office. With that, I give you Thad Baraday, and I think a good place to start that may be to tell us how, from a remarkably industrious M&A associate, how you got to WellCare, and give us a bit of a sense about the company before that day in October of 2007.
Sure. Thank you so much, Ned, for the introduction, and thank you for having me. It's really my first time back to my alma mater, where I graduated in 1993, and it's a real pleasure to be here and see you all again. Thank you for coming out. I appreciate the interest in my journey and the opportunity to speak to you all today. This is not a journey that turned out the way I expected, and I never ever thought that I would be here talking to you all today about the topic of criminal justice reform, which I know is not the answer to your question, but I just want to headline the end of the story because I'd like to make sure we get there in the limited amount of time we have. As Ned said, I left this distinguished institution and started my career at Jones Day here in Cleveland. I went into corporate transactional practice, but I always aspired to something more. And for me, there was always this challenge of what's next and what's out there that distinguishes me and helps me make my place in the world. And because I was in a large corporate law firm doing transactional work, I was always intrigued by the business decision maker. And my heroes became lawyers who graduated to go on to do something beyond the law. Entrepreneurs, CEOs, politicians, leaders, and I aspired to be closer to the business decision-making process. So I wound up pursuing a career out of private practice as an in-house corporate counsel. Actually did my first tour of duty in-house at a public company based in Columbus, then did sort of the corporate gypsy thing for a number of years, went back to Washington, D.C., and ended up in Tampa, Florida at WellCare Health Plans. WellCare was my first experience in the healthcare industry. I'd done more sort of old line industrial public company securities and corporate transactional work prior to that. And then kind of went through the internet revolution, which didn't work out so well, and ended up in healthcare. And so that was my first experience in healthcare, and certainly, hopefully, my last. So to talk more specifically about WellCare, WellCare was a very large vendor at the time to the state of Florida and 2 other states, and the state was on a journey of modeling its managed care program. This is for Medicaid recipients who are, in some cases, elderly, but low-income patients who receive the benefit of a state federal matching program. And the state of Florida was, at that time, one of the leading proponents of outsourcing the care for that community to private industry. And WellCare was a large vendor in the state, actually the largest vendor in the state, who was doing that type of work. So we were a Medicare and Medicaid managed care plan, so a government programs vendor. And when we purchased the company, ironically, it was highly, highly troubled. It had gotten into some very difficult financial circumstances under its family founders who were entrepreneurs. And we were perceived as the white hats who were coming in to rescue this troubled business. So we were welcomed and blessed by the regulatory authorities for bringing in new management expertise and new capital to this transaction. And we led a turnaround of the company that went quite well.
So, I think a way to structure this is we'll leave time at the end for your questions and comments, but moving ahead, just give us a brief sense. So, if we take the date October 21st, 2007, you're general counsel over a publicly traded company, $1 billion company. How did you feel about WellCare from a compliance perspective? Did you go to bed at night worried that what would happen the next day was going to occur?
I definitely went to bed at night worried, and that work ethic that you mentioned that I learned where we had first met at Jones Day definitely continued through the balance of my career. And as I said, we were executing a turnaround at WellCare of what was a highly, highly troubled company. I'll never forget, in the first 2 weeks after the acquisition, we completed the first ever computer backup of the main claims file systems that had never been done by our predecessors. So there were a host of challenges. There was no law department at the time that I started. There was one in-house attorney who I retained, but he was sort of buried in a basement in a cubicle, never had any interaction with the senior leadership team. The company had a huge portfolio of litigation that was pending, a couple pieces, some of which were garden variety, but a couple pieces of which were sort of bet the company situations. So we had all sorts of fire drills and presided over a period of intensely rapid growth. So we acquired the company in 2002. By 2004, we were able to lead an initial public offering, an IPO, that was perceived to be the most successful public offering in the healthcare space on Wall Street. And I'll never forget when the CEO came to me and said, okay, now we're ready, we're going public. I was like, what are you talking about? We are still laying the foundation of Sarbanes-Oxley was a big issue back then. HIPAA was just rolling out back then. We were actually worried about Y2K, and there were just all sorts of compliance challenges. I was like, the idea of meeting the hurdle to go from a privately held company to a public company was daunting for the general counsel. And what they said was, well, Wall Street wants to share in the company's success. The underwriters want to see you go public when there's still upside. So somehow we did it. We pulled the company together, and by 2004, we had launched the IPO and rang the bell on the floor of the New York Stock Exchange. And the company was very successful up until 2007, the date you mentioned, which was the date of the FBI raid. We had expanded from 3 states to 10 states, from 300 employees to 3,000 employees, and from 300 million in revenue to over 3 billion in revenue, and become not only the largest provider to the Florida Medicaid program, but one of the largest providers to the national Medicare prescription drug program. So I think we think we had about 2 million members that we served at that point in time.
Well, I'd love to linger over the happy moment that you see in the picture, but let's go to October 22nd, 2007.
All right, and I don't like to focus on this, Ned, but as you mentioned, WellCare was a highly successful company until it wasn't, and that changed on October 22nd, 2007, when we were raided by 200 government agents in a total surprise ambush. The government timed the raid to coincide with a meeting of our public company board of directors, so all the big bosses from out of town were in the building at the time.
You were in the building.
I was in the building. We had just started the board meeting. We had many leading luminaries on our board. We had the former head of the Florida Medicaid program. We had who had been the deputy of the Center for Medicare and Medicaid Services, the federal government agency. We had Senator Bob Graham on our board. We had Professor Regina Hertzlinger from Harvard Business School. Needless to say, these were not people who expected to see 200 federal agents bursting through the door, wearing flak jackets, sidearms, calling out names, herding our employees into conference rooms, yelling at secretaries as if they would push a button and delete all the evidence. It was truly terrifying. It's just like you see on TV. And we were being treated like criminals. And I had never, ever expected that the criminal justice system would affect me.
So that was it. Obviously, you put up the Tampa Bay Times. It was a national news story, and the number that just jumped out at me when it hit my computer was I had never seen a search warrant of that scale at that time. Are there any lessons? I know there's some in-house counsel here, and are there any lessons that you take out of that about how companies should handle this situation? Because I don't want to sidetrack us, but this situation is less unique than you may today.
So we could spend the whole time just on that topic. What I learned was when 200 FBI agents are mobilized, when the federal government commits that mobilization of resources, the game is over. I didn't realize it at that time because this would start a decade-long odyssey for me through the criminal justice system and learning about it and mounting a vigorous defense, initially on behalf of the company and then eventually on behalf of my colleagues and myself individually. But when the government mobilizes that scale of resource, somebody's put their badge on the line and somebody's going to go down. Turns out that person was me. I just didn't realize it at the time.
Talk about the immediate steps that the company takes after the agents finally leave. You are the general counsel. You're over the legal function. What are the immediate things that happened in the weeks after? And I know this is another question you could take an hour on, but hit some of the high points.
Yeah, so, I mean, obviously, the immediate issue on the day was to secure the company, cooperate with the agents, assist in the investigation, secure the board, the officers of the company. We immediately imported literally dozens of lawyers who started interviewing the people who'd been interviewed by the agents, trying to figure out what was going on. We had absolutely no clue, no forewarning, no idea that the federal government was even interested in us at this point, even though we interacted with federal and state government authorities in other agencies on a day-to-day basis, and that's what we did. Because the raid had occurred literally during a board meeting, that meeting had been adjourned so that the board members who were not involved could leave, and then we reconvened a week later. That week felt like a lifetime, and the board appropriately convened a special committee of disinterested directors, outside directors, who would then lead the initial process of responding to this investigation, engaging outside counsel and trying to figure out what the heck was going on at the company. We learned quite quickly that this was a whistleblower fraud case. There had been an inside employee who was responsible for calculating the numbers that were at issue in the regulatory matter that we were eventually charged with, and he had been wearing a wire. We didn't know this till much, much later, but he'd actually been wearing a wire for 18 months and had recorded over 800 hours of daily interaction at the company with people that he worked with, meetings that he went to, people in the restroom, all sorts of things. Just, he would turn the wire on at the beginning of the day, turn it off at the end of the day. We went home, we were all working very hard, and he recorded all sorts of things. So it was a very wide-ranging investigation, and at the outset it was very challenging to get our arms around what exactly it was the government was interested in. There's this one thing that became the basis of our prosecution. But what was immediately clear was that there had been a complete breakdown and crisis in confidence from the standpoint of governmental authorities looking at this company and its management team as a trusted vendor with whom they could do business.
Is this a good point to just give the audience, people that haven't read the eventual Federal Court of Appeals decision on this case, but give them an understanding of what this issue is? And I would preface it by saying what's interesting about fraud cases, and this case may be the best example of it, is, if we take a murder, there's no issue that a crime has been committed. Somebody has been murdered. The physical evidence shows that this person didn't die of natural causes. Issue becomes whether there's evidence to show that a given person is responsible for the murder. What's interesting about fraud cases is there may be a debate, and there certainly was in this case, whether there was even a crime. The government looks at something and says, this is criminal fraud, and the defense attorneys and the executives look at it and argue there's no crime at all. So give the audience a sense of what the issue is.
Yeah, so with this audience, we have several law students in the room, and as we know, lawyers are trained to argue both sides of every issue, and we get into a court of law and we sort of determine the truth. And at some point at the end of the day, one team, one set of lawyers, one side wins and the other loses. So in this case, and we had a lot of lawyers looking at these issues and arguing both sides, what our team, and myself included, saw as a valid business strategy, federal prosecutors looked at and saw as a fraud, and they won. They just won. So we were prosecuted for a rather obscure provision buried in Florida Medicaid law that I've spent 10 years in conference rooms thinking about and looking over, but it's commonly called the 80-20 law. And it was a refund requirement in one portion of the overall services of the Florida Medicaid program, what's called mental and behavioral health care. We were paid to provide for the total medical needs of our patients, and behavioral health care was one subset or small category that was a wedge in the overall pie of the services that we provided. And the Florida legislature had passed a law that said for every dollar received in that small category, you had to spend 80 cents on direct patient care, or you had to refund the difference back to the state. There were all sorts of problems with that law. It had been adopted without any legislative hearing. It was sort of in the dead of night, tacked onto a rider. It was not something the industry or even the regulators had any warning was coming as a new issue. And we were all caught flat-footed for it. Frankly, our customer, the Agency for Healthcare Administration in Florida, didn't really want the law. It had been put into place by the adversaries of managed care the community behavioral health providers who had been previously unmanaged and were resisting the state's move to gather these areas of healthcare delivery and bring them under the auspices of private market managed care programs, where we were sort of putting the screws down on providers and trying to extract efficiency and make healthcare delivery more effective. So they were saying, no, 80 cents of every dollar has to be put back in the pockets of those delivery providers, or else it doesn't count. All sorts of problems with that. The industry is up in arms. There's no uniform accounting system to track what expenses are allocable to just that wedge of the overall pie. The state doesn't even tell us what portion of the dollar we receive is allocated to that pie. So there's all this math that has to go through to try and figure out, well, of the total capitation that we're receiving from the state, this portion of the wedge belongs to that portion of the expenses, and then if you can allocate the revenue right, then how do you match the expenses to it? So it's a huge accounting cluster. And as a result, the state of Florida delays the implementation of the law for a year, but they never go through any rulemaking or comment process or any sort of normal regulatory oversight that you would expect to come to common agreement with the industry of how are we going to manage this, how do we account for it. And so instead what happens is they just start issuing this very short 4-line item kind of worksheet that we're supposed to calculate and figure out how to respond to. The industry starts an initiative to repeal the law because they're like, this is totally inconsistent with the principles on which we're paid and the whole thesis of managed care. And the state starts sending us transmittal letters with this worksheet that sort of sets forth their point of view from their in-house general counsel's office as to how the law should be interpreted. And I remember on our side, in the general counsel's office of the managed care health plan, we would look at those transmittal letters and laugh, because it would be equivalent in your world, Ned, to receiving a legal brief or pleading from your adversary. We're like, well, that's a clever argument, that's interesting, but it's inconsistent with the express language of the statute. So if we come to a contest on that, when we go through this legal process to a court of law and try to determine what the truth is, we know we will prevail, and our statutory interpretation will quash your cover letter perspective on what you think the law means. And that's the way we proceeded for 5 or 6 years with this sort of simmering dispute as to how this law was interpreted. We had an accrual on the books of our company for about $10 million related to this issue. We disclosed it to our auditors quarterly and annually to talk about, how this dispute with the industry and with the regulatory position might get resolved. And we exploited a loophole in the statute as our method of compliance with this requirement. We essentially created an affiliate company transaction. We dropped our behavioral health operations into a wholly owned subsidiary that became our captive behavioral health care delivery vendor. We paid that vendor that was our sister company 80 cents on the dollar and reported that money back to the state as our compliance with the statute. We disclosed that to the regulators. They really didn't care. They didn't like the statute that much to begin with. And the dispute was just sort of simmering and percolating along. In fact, we really thought it had been resolved, because I think by 2007 the accrual had been removed because there had been no action on it. And then 200 FBI agents show up on our door, and this is now the crime of the century.
There was no concealment of the relationship with the...
No, in fact, this structure was created by our outside counsel, who was also the general counsel to the Florida Association of Health Plans and had previously served as the director of Florida Medicaid. So he actually created the Florida statutory regime that launched the Medicaid managed care program. And because he was kind of a sole shingle local practitioner up in Tallahassee, I made sure to vet his analysis with our outside corporate law firm, which was Greenberg Trauig, They actually drafted all the contracts to implement the structure. It was disclosed to the regulators in the ordinary course pursuant to the methods that existed within the industry to disclose affiliate company transactions. Actually, and unusual for healthcare fraud cases, the behavioral health delivery subsidiary was audited all the time by regulatory authorities, received A+ marks, was actually doing a great job in marshaling the delivery network and providing excellent, really exceptional patient care to our members. So there was never really a question about denial of services or overbilling of claims. It was really just a question of the interpretation of this statute and how the monies paid get allocated in an accounting method to meet the refund requirement.
So let's move forward with the story of where you are in the early point, for you, the early point of learning about this investigation. Of course, the investigation's been going on for some time, as you mentioned, with whistleblowers reporting you and others within WellCare. You mentioned a special committee. How does the involvement of the special committee change your role in the company?
Well, it changes everything. It is consistent with the ordinary operating structure that all public companies have, where boards of directors and officers have duties to uphold the best interests of the corporation and its shareholders. And it's the garden variety playbook 101 next move that you do in the wake of a crisis like this. So it was clearly expected, but this was a seismic shift for our company. And really, we felt that the livelihood, the viability of the business was at stake. In the immediate aftermath, we had to do a total crisis management intervention with our regulatory customers, the government regulators who provided us our contracts, to make sure they understood that we had a special committee in place. We were hiring independent outside counsel who were going to look into these matters. We were cooperating with the authorities, and we were responding appropriately. But had any one of our government regulatory customers lost faith in our business and pulled their contract, which they had any number of theories or bases to do, that could have really triggered a domino effect for us and been mission critical for the company, and then millions of members of patient care would be disrupted. We were also probably in violation of debt covenants. I mean, we were in this was the crisis management plan of my career, and we were in oops, I went too far. We were in I'll put that. We were in a real depth of situation. But the biggest change for me, Ned, was the appointment of independent counsel to the special committee, which can be a bit of a political process, but that was the world in which I walked. You know, as an in-house general counsel, especially for a large public company, we did business with hundreds of law firms across the country, from very high-end white shoe Wall Street type law firms to smaller solo practitioners, depending on different cases that we had, as well as specialized regulatory experts in various areas. But matching the right lawyer to the assignment is sort of the bread and butter of day-to-day in-house general counsel life. And the special committee counsel, who was Davis Polk and Wardwell, a very, very well-respected white shoe Wall Street law firm, they really become the new sheriff in town in this type of crisis environment. And they effectively operate, as they did in this case, as a deputized adjunct of the United States Attorney's Office. So they were conducting an internal investigation, but because of their perceived independence and their sort of outside role, the United States Attorney relied on them heavily to chart the course of the next steps for the company. And I don't want to put too much into that, because I'm sure that, as you know, as a former prosecutor, the U.S. Attorney's Office has got a lot of resources of its own and is very independent, and makes its own judgment, but there came to exist this delicate dance between the independent special committee, counsel, and the U.S. Attorney's Office, and that's really where the action unfolded.
And they're trying to save the company. They're not trying to save you. And at some point, you realize that you're not only losing control over managing this crisis.
Yeah, it's funny. One of the lawyers that became my personal counsel, who I spoke to early on in this process, he was from a Palo Alto law firm called Wilson Sonsini, and he said, "You're not going to have a job in 2 weeks." And I was like, "What are you talking about? I'm running this crisis. I'm engaging the counsel. I'm essential to the process, of course, And it took 2 months, but he was right. The crisis of confidence that was apparent to the board and to the special committee was a crisis of confidence in management. It was basically a sense that the management of this company could no longer be relied upon, and we had to go. So the CEO was dispatched, the CFO was dispatched, and although I was hopeful that I might be retained because of my essential role as a lawyer, that's not the way it worked out, and I was dispatched with them.
In this process, you realize that you're not only losing your job to restore confidence in a publicly traded company, but you're a target of a federal criminal investigation.
So you asked me that question ahead of time, Ned, and it's hard for me to pinpoint because the climate, the environment of terror that is created by this level of deployment of government resources really was pervasive, and everyone was terrified, from the board of directors on down to the lowest level secretary. And so we all knew that there was a great deal of peril in our midst that affected the company and its individual agents. And certainly once I was terminated and put on the outside of the walls of the company, which was very quick, that did not feel good. And it is very typical in these scenarios for special committees to be engaged, for management teams to be severed, and for the company to create a new look and feel and a new clean slate with new management. So the prior management team is at risk in that scenario. I still, for years, did not perceive the level of risk that we were being placed under. And I had individual counsel, some of the best in the country, who were advising me to that, but I still truly did not believe it because I just felt like the facts would save us. Unlike many other issues you asked about sleeping well at night, there's a myriad of challenges facing this company on a day-to-day basis. And the things I really lost sleep about at night were the ones that I didn't know about, the ones where we didn't have lawyers engaged, or we didn't have strategies in place. And this was one where I felt I hired the best lawyers in the world. We really looked at this, we really worked at it. We had a strategy in place. Surely our lawyers will stand by us and we will be vindicated and our strategy will prevail. And I could not have been more wrong about that. So we were indicted in March of 2011. I certainly knew by then. As you know, Ned, and these are all things I learned first time. I never knew this happened, but the United States and the United States Attorney's Office around the country has a policy of issuing target letters to prospective individuals. You can probably explain the history of how that came into effect. So I had received a target letter sometime before that, maybe 6 months prior to that, which was totally terrifying. But my counsel, even after the target letter, believed that we could persuade the government not to indict us.
Let me stop you there, because it wasn't us. It seemed like the group that got indicted, and not everybody that got counsel got indicted together, but you were in your own unique category, right? And let's talk about this for a moment, because you were general counsel, and I often analogize these cases to an old movie that a lot of you have never seen, but Rosemary's Baby. And the government has this view that when you realize that people around you are evil, you need to get out. But the general counsel isn't necessarily, or the compliance officer isn't necessarily expected to run out at the first whiff of some problem. You're expected to fix it, right? So talk a little bit about the ethical issues around it in the, again, we just have too little time, but, the unique issues around indicting the general counsel with the rest of the management team.
Yeah, so I firmly believe I was indicted at WellCare because I was the general counsel. And this is another emerging area of law that unfortunately I had to sort of learn about on my back, which was the growing threat that in-house attorneys face to challenges like this. Now, I had grown up in the Sarbanes-Oxley era that imposed heightened duties on lawyers to sort of and raised questions about the lawyer's role as ethical advocates. And there's a great debate in the world I used to live in corporate circles about what are the right stakeholders, who are the proper constituents that corporate executives and officers can take into account in thinking about what's in the best interest of the company. Does that extend more broadly to employees, to customers, to maybe even broader community stakeholders? Particularly important when we start to think about issues like global warming and pollution and other things where corporations can do a lot of harm while still pursuing the best interests of the company and its shareholders, but there may be broader interests at stake. So without getting into that debate, the challenge from the standpoint of the general counsel at WellCare was that we did not believe our actions were even illegal, much less criminal. We had a very well orchestrated strategy that for us was a litigation strategy that we believed was reasonable, defensible, and in fact would prevail in the appropriate forum if those issues ever came to be contested. We just never anticipated that contest would play out in the unique structure of the federal criminal courts, where the rules are much different and frankly the odds are stacked against the defendants. And I think my indictment was in part designed to disable my colleagues who were more directly involved in what was a complex accounting case from making the defense at trial that my lawyer had told me I could do this and my lawyer had told me this was okay. And I talked to my lawyer and he thought what we were doing was all right, which I certainly would have said. And frankly, I was planning to say at the trial, but I got some bad news just a couple weeks leading up to the trial.
Let's talk about that a little bit, because as defense attorneys, we believe that at the point you've been indicted in a case like this, you've already lost. Even if you're eventually acquitted, your life will never be the same. I know you've talked candidly and openly about what happened to you personally, and you just made reference to the bad news. How did getting indicted and that situation, how did that impact your life?
Yeah, so I think when I got indicted in March of 2011, people always ask me, when is your bottom? And this case and story is difficult because you're sort of skidding along the bottoms and you try and nose up a little bit and then you bounce further and you're like, oh, maybe this is my bottom. No, it's getting worse. Maybe this is my bottom. But so for me as a lawyer, because I still very passionately, to this day, I sort of hang on to my status and identity as a lawyer. And in March of 2011, being formally indicted in the criminal proceeding by a federal court, there was a time in my life when I used to think like receiving a letter of inquiry from the SEC was the worst thing that could possibly happen to you. But when the United States versus Thaddeus Paraday is at the top of a form, it's pretty jarring. So it was awful. It was terrifying. It was It took an immense toll on me personally. It took an immense toll on my family. I did not have effective tools to manage myself personally. I've learned a lot about the importance of self-care since then, but mental health and substance abuse challenges and recovery are now part of my story. And honestly, by end of 2011, 2012, I was suicidal. And I was praying I always had been a person of faith, and when you get into these crises, you sort of retreat back to what's most important, your family, your health, and your faith. And I'm not certain I did a great job on any one of those, but I was praying to God to save me. And 2 weeks before the trial was scheduled to begin, I got the news that I had leukemia. And it was one of those Grey's Anatomy moments where I thought I had the flu or something, and I thought I was just under a lot of stress and pressure leading up to the trial. And I found myself in the hospital, my wife weeping, and the doctor comes in and says, "Mr. Barrett, I regret to inform you that you have cancer." And I said, "Doctor, I can't have cancer. I need to be in federal criminal court in 2 weeks. I got to defend myself. It's like the most important time in my life." And he was like, "No, Mr. Barrett, you probably have 2 weeks to live." And I didn't know that in these dire circumstances, one could receive a doctor's note to sort of get out of jail. But I literally got a doctor's note and wound up being severed from the case, which proceeded against my 4 colleagues, the CEO, the CFO, the head of the business unit, and a finance guy who supervised the whistleblower, who were indicted and went to trial without me. And so the moment I mentioned when I would have likely testified to say, "Yeah, we looked at this, and this was something we believed was legitimate," that never came. And that created a big, big hole in the anticipated trial defense for my colleagues. And of course, I lay in Moffitt Cancer Center, losing my hair, going through chemotherapy, feeling miserable. My wife, who's also was my classmate at Case and also graduated of this law school, she attended the trial daily and would bring reports back to me. But I felt not only crippling health debilitation going through chemotherapy and the nausea of the cancer, but crippling guilt that I had abandoned my colleagues on the courthouse steps and they were going through this process without me. And eventually all 4 of them were convicted.
So, you had a terrible fight with cancer, but it didn't excuse your own need to face a trial. So at some point, we're back in a position of having to be tried on this case, having seen your colleagues get convicted and their defense not prevail. And so I know there's a limit to how far you can go into this, and we're not asking you to waive the attorney-client privilege, but explain how you get to the decision you made.
So that part of the story played out over a number of years as well. And as you mentioned, all 4 of the executives were convicted at the trial. There were a lot of problems at the trial, and there were quite a few issues with the trial process and the convictions themselves. But at the end of the day, all 4 of the executives were convicted, and that's all that mattered. Then the focus shifted to the appeal in the 11th Circuit. And the CEO hired the best lawyers in the country to prosecute the appeal. They filed beautiful appellate briefs. And about that time, the trial judge issued very lenient sentences. This had been a 2.5 month trial. It was top of the fold, national headline news around the country. Every white-collar criminal defense lawyer in Tampa had a piece of this case. It was a big focus, and yet the CEO received 3 years, the CFO received 2 years, the head of the business unit received 1 year and a day, and the finance guy received probation. So there was kind of this disconnect between all this mobilization of government resources and this national attention, and for what the judge said in his sentencing was a mistake.
Can I interject on that point, because it's probably worth lingering here for a moment, but the reports I got back from my friends who were in that trial was it was a tough trial from the defense side, and there was no expectation that judge was going to give this downward variance. So the situation you had in WellCare that plays out today in fraud cases around the country is, there's an argument about whether this was an honest misunderstanding or fraud. And when the government wins that argument, you get from a group of defendants that have a defense of advice of counsel from, some of the most prestigious firms in America. They go to facing the federal sentencing guidelines that base your sentence based on the loss. The loss here was huge. So these people went to that sentencing facing the possibility of never coming out.
That's right.
Given their age.
Right, and the United States Attorney was seeking 20+ year sentences. So that didn't happen. And then the appeal was pending. Now, 2 weeks before the oral argument in the appeal, my cancer relapses. So there starts to be this connection that I'm seeing and my wife is seeing between the sort of peak stress levels involved in this legal proceeding and my personal health. So that's part of the answer to your question of, how I got to the circumstances that I got. But we really had very high hopes for the appellate process. Appeals are generally low percentage opportunities. We maybe had a higher optimism level than is typical, but we wound up losing at the 11th Circuit across the board. And there was no wisdom of Solomon. It was a resounding defeat. And that very much hurt my circumstances, because at this point I was isolated as an individual. We'd been hoping there would be some mercy for me from the United States Attorney's Office, that maybe this guy suffered enough, and now so much time had elapsed, and I'd been punished in ways that are extra legal but pretty serious, and we just really were hoping that they might leave me alone. But emboldened by the win in the appeal, and ironically, then Jeff Sessions coming into office, they made clear that we were headed to trial, and I and my team had to make a calculation of how that would work for me. This time being tried as a sole individual without kind of the broader case to be made around the accounting issues. This was another learning milestone for me in my journey through the criminal legal system. There's something very profound in our system called the trial penalty, where if you pursue your rights and try to establish your innocence and get your day in court, which I really felt we had not achieved in the original trial, because of course my role had been precluded, you are severely, severely punished. And I think we were concerned that with this connection between the peak stress levels in the legal process and my health, we thought that living through trial could be a death sentence for me. So I wound up taking a plea agreement that was negotiated to a single count of making a false statement for one of those healthcare refund requirements that I'd mentioned. And we were hoping that I would receive probation, but the sentencing judge made clear that lawyers needed to be held to a higher standard. As the company's chief counsel and chief compliance officer, I should have known better and could have stopped this whole thing from happening. And he wanted to send the message to other in-house counsel like me that this shouldn't have happened. So I did 6 months in federal prison at Jessup Federal Prison in Jessup, Georgia, and then I did a year of home confinement wearing an ankle monitor. I mentioned the bottoms of skating across. I have to say that, federal prison and being sentenced to jail was another low point.
It was humiliating. It was safe there.
Well, federal prison stinks, and I would not recommend it. It was, I think, the modern day equivalent to being put in the stockades, to being publicly pilloried in the town square and having people throw tomatoes at you. That's really what it felt like. It was more than humiliating. It was debasing, demoralizing. You are stripped of your humanity and dignity. And again, I just never ever imagined that this could affect me. And it very sadly proved to be the final straw for my then 30-year marriage. After all the healthcare and all the legal challenges, my wife let me know that when I got out, we were not going to be married.
It's about your decision to do what you're doing now, briefly, because I do want to open this up to questions.
As a sort of a final question, talk about what you're doing now, why you're doing it, and the kind of surprising end of your story.
Yeah, and so not much works well in our nation's prison systems, and federal prison, which works a little bit better than most state systems, is certainly not ideal. And when you are incarcerated, you can't unsee what you see there. And so that has colored my perspective. And the one thing that did work well for me and was completely inmate driven was the men's Christian ministry. And I'd been a devout Christian my whole life and sort of went to church and grew up that way. But I decided to make my time inside a deep moral, physical, and spiritual journey. I did a tremendous amount of self-reflection and a lot of work on myself, and I was supported by a great group of men who were my fellow inmates. I also got to eat with, bunk with, and live with people from very different walks of life who were people that I never would have encountered but for this experience. And these are the people who are truly impacted by the criminal justice system. So we've talked, frankly, more in this forum than I usually do about the facts and circumstances of WellCare and what happened to me, because I really feel like that's not the story here. The story here is what's actually going on day to day in how our criminal justice system operates and impacts people in communities of poverty, which are disproportionately communities of color. And I believe that we as lawyers hold a very special obligation and responsibility to call attention to this question, because we created the system, we write the rules, we administer it, we design it, and it's not enough for us to say, oh, this is just an unfortunate impact of the way things work. It's actually intentionally designed this way to systemically oppress communities who don't have the power that we have as lawyers, who don't have the power that we have coming from privileged communities and going to institutions of status like Case Western. And it's unfair. And I now devote my life to trying to call attention to this issue. And I hope that is a silver lining from it. So I became very socially justice motivated when I got out. I started working with homeless men. I learned how to serve. I joined a very socially justice active church community, and then something really incredible happened. In 2021, I received the miracle gift of a presidential pardon, which I did not seek. I had no idea it was in the offing. It's like I'd already been struck by lightning, and this whole didn't think it'd be struck by lightning again, but there it was. It showed up. It was pretty amazing. And I took that as a sign from the universe that I should continue this work and continue calling attention to what is really going on in the system.
Let's take one more minute about, because it goes back to WellCare case and how it's become viewed over time by really a broad cross-section of the political spectrum. What led the president to pardon you? You
weren't soliciting this, correct?
No, I had, again, so I had nothing to, I woke up on Inauguration Day sort of pleased at the turn of the chapter and that the, Trump era was over and we were going to move on to what was coming next. But I had no idea that this was even a possibility. So unbeknownst to me, while I was dealing with cancer and going to jail and dealing with my own experience through this, there had been a very strong movement in conservative political circles of think tanks in Washington, law school professors, sort of very, kind of righty-right institute, Cato, Heritage Foundation, who had gotten very focused on the WellCare case, and they were joined by groups like the NACDL, so it was a pretty bipartisan group, but there were all these articles and this sort of scholarly movement to call attention to the fact that executives and companies should not be prosecuted for regulatory guidance that is contained in transmittal letters. If we're going to use that type of regulatory basis for criminal prosecutions, it should go through the formal channels of notice, rule, comment, publication in the Federal Register, that type of thing. And many of those officials wound up in the Department of Justice under the Trump administration and actually rewrote the standards for prosecutorial policy in this country. So and I'm not an expert on this, but my understanding is a case like WellCare could not be brought under today's Department of Justice guidelines. Curious footnote, the statute that we were prosecuted under in Florida was eventually repealed. Too late for me, but it was. And the White House, in issuing the presidential pardons, referred to WellCare as a case study in overcriminalization. So I think that resonated with the president in his desire to contract over regulatory reach in our government.
That became one of the areas of sort of bipartisan agreement was the need for criminal justice.
Let's take your questions and comments from anybody.
Did the company live up to its advancement obligations all these years that you were under investigation and defending yourself?
So they did. This is a happy fact for me personally, but actually a very sad fact for me as a former executive, shareholder, and person who cares about this business. WellCare spent $500 million providing for the legal defense of all the people who were involved in this process, as well as its own legal defense. A tremendous waste of shareholder resources, in my opinion, and a level of access to resources that almost nobody in the criminal justice system enjoys. So you don't have to cry crocodile tears for me. I was extremely well represented and defended, and yet still got pretty rough treatment from the system. But think about the kids who are bent over the hood of the cruiser, who get an overworked public defender, if they're lucky, who spends a very short amount of time on their defense. And 98% of federal criminal trials are settled by plea agreement without the right to a day in court. Okay. This gentleman has the mic.
You kept saying you were going to leave time for questions, but you, in fact, asked all the questions, so I'm going to cram all mine in. Why did the whistleblower first go to the authorities 18 months before? What was this, the 80% thing? What did the whistleblower's evidence consist of? Were there any smoking guns? Counsel, you said the loss was huge. What was the loss that the FBI or the United States was so exercised about? And was the whistleblower remunerated, and how much did he get?
So the loss was $35 million spread over 5 years. It just barely meet the materiality standard for our financial statements in 1 year of those 5 years on net income, not revenue. So it just squeaked over the standard materiality. The whistleblower did go to the authorities. He was represented by one of the best attorneys in Tampa who specialized in these types of cases. He was a master media manipulator, had a lot of connectivity with political leadership, and think sort of Johnny Cochran-esque of Tampa, Florida. And he got the FBI, the local FBI office, engaged in this case. So the whistleblower was wearing an FBI-provided wiretap, which I learned Florida is a single-party state for wiretap communication. So there's no court order, there's no judicial finding of probable cause at that stage in the process. It's just, does the FBI determine that there's enough basis to send a willing party in to wear a wire, which they did. So smoking guns, I spent 10 years in conference rooms poring over thousands and thousands of emails and have thought of hundreds of things that I could have done better in this case. So there was substantial circumstantial evidence that the government used effectively to draw an inference of intent. And that's really where the debate was. And the whistleblower get a lot of money from he and his counsel shared about $50 million.
Eric, how should we handle this? Because we're over. Can we take 2 more questions and then if
We
others?
could just say goodbye and stop the recording and then
Okay.
have questions from people who want to stay.
Okay.
Why don't we do that? So if people want to leave, we're over our time. But we'd like. I think there are 2 questions. Feel free to ask them, and that's.
Thank you very much for having me here today, and I'm really grateful for the opportunity to speak to you all.
Thank you.